The first Parent Act was passed by a special majority, and the issue arose as to whether subsequent amending pieces of legislation could be passed with a simple majority. But there are serious constitutional issues, and it is not simple to say use Surratt and Barnes and the others, Northern and so on, and talk about proportionality. Because proportionality has to do with a legitimate aim. Is it a legitimate aim to create a parallel procurement system outside the independent office, the procurement regulator, and put it in the hands of the status quo, which is the executive, the cabinet? How can that be a legitimate aim? And that can raise issues now having to do with constitutionality, about inequality of treatment, about unfairness, about discrimination, because you're using two different systems. One where you as an executive sitting making decisions, and then one where the independent office of the procurement regulator is being undermined. The Honourable Minister really raised a very confusing issue, which I'm still putting my mind to, and that's why he's very clever with being disingenuous, when he told us, you know, well, we had tendering under the CTB. That was 1961. I'll remind him of that. Thereafter, the law changed to allow the armed forces. That's how you could buy the boats and so on through them. There was an exemption for them from using CTB. And then NIPDEC was introduced by 1993, I believe, or the other way around. And up from 1993 now, there's been no change in the procurement law. The Ministry of Finance created a divestments manual, like rules. Does that have the force of law? Just a manual with rules created by the ministry about how you procure and how you dispose. But here it is now, the minister tells us, well, you know, state enterprises, judgment by Justice Warner and so on, not subject to judicial review. Not subject to judicial review. State enterprises with these contracts and so on. But that's the reason why you need this procurement law. That's why you need it. Because you don't have scrutiny. You will have scrutiny under this. But no, you don't want that to happen. So you say, let's go back. You don't want a court to come and overturn. That's exactly why you need the law. Minister, you're being disingenuous. These are the things that over the years, there's a Bala report from 1987, I think it is, with all the government-to-government contracts, all the corruption that went on with the Mount Hope complex, we could name all of them, French company, foreign company, all these government-to-government contracts, riddled with corruption. And that 1987 Bala report said, look, get rid of this government-to-government issue, too much. Then you have the private-public kinds of partnerships that could be subsumed under these same sections. And we remember the scandals, the Sandal scandals, where it was a disadvantageous deal to the people. If we had the procurement law, the government couldn't go out and sit down at a lunch table and make a deal. That is what we were told by none other than Arthur Lock Jack, that you can, they were eating lunch or dinner, and they made that arrangement. That's why we need the procurement legislation, Act 1 of 2015. That's why we need it. And you know, the minister started off by buffing the media. Typical kind of reaction. Buffing the media for their comments. But I want to share with you the voices of the people on the issue of this procurement legislation. We have the public sector, private sector, civil society group saying that they're deeply distressed about amendment to procurement legislation. They talked about the delays and the promises broken. PNM promises never materialized from since 2015, right down to this year. They talk about it saying that they're deeply concerned, and this is signed by Winston Riley, represented the JC, AmCham, the Chamber, TTMA, Trinidad and Tobago Transparency Institute, Trinidad and Tobago Local Content Chamber, and TTCSI. And they said that all these statements, this is still here in limbo and in abeyance. And they were deeply concerned that it had reached where it had reached. They said they had written to the Prime Minister on November 20th. They issued a press release reminding the Prime Minister of his commitment on September 29, 2020. And of course, now the rest is history, where we don't have that coming into effect in spite of all the promises. We also have the JCC, which tells us that the proposed amendment to Section 7 provides status quo to the Minister of Finance and for all intents and purposes nullifies the intent of the Act, the substantive intent of the Act. In particular, Section 7 of the Act is proposed to be amended to delete that where there is a treaty, there is an agreement and so on, that this is going to be removed because you would have to keep it still within the Act. So the treaty will not prevail above the substantive intent of the Act. And that too is a serious issue, which I raise on constitutionality. It's public funds you are spending. It's taxpayers' money that is being expended. And therefore, there must be scrutiny from an independent person. The Office of Procurement Regulator, in an advisory dated 3rd December 2020, that is yesterday, said, they maintain the position that Clause 5, which seeks to amend Section 7 of the Act of 2015-1, which is that they don't want to change. They're saying a thorough consultative process was undertaken between 2018 to present with stakeholders across various sectors. They provided feedback from their workshops, 20 workshops, 193 sensitization sessions, webinars held with over 1,400 suppliers, contractors. And during these consultations, stakeholders reiterated that there should be no amendment to Section 7 as it stands. No amendment. From the OPR and from all their consultations, no amendment. They emphasize that Section 7 should be given an opportunity to be tested, since there is a real possibility that local suppliers and contractors may be deprived of a fair and equitable chance to participate in procurement proceedings. And that is the same issue of constitutionality, of equality of opportunity, equitable chance to participate. They continue, any variation to this provision may undermine the objects of the Act, namely accountability, integrity, transparency, and value for money. At all times, stakeholders continue to emphasize that these arrangements under Section 7 ultimately will be repaid with public money, and so these transactions should fall within the ambit of the Act to achieve the objects of the Act. Additionally, there should be no exclusion from the OPR's oversight in respect of the procurement of legal, financial, accounting, auditing, medical, and any other service, as the Minister may by order determine. Should be none. No exemption. This is the Procurement Office. They've been working since 2018. They've done a lot of work, including the prep of the regulations. We would have thought you'd be coming here to lay the regulations. Instead, you come here to gut the Act. Minister said he's not gutting anything. What are you doing? You're taking out substance. You're taking out that which is important for the integrity of the process. You're taking out those things that will make a fair procurement and disposal process. Government making procurement law toothless. I commend former MP Boti Bari, who was very instrumental, together with MP Tim Gopi Singh, I believe, and A.G. Ram Logan, who served on the JSC for our side at that time. They did a tremendous job. They met with so many stakeholders. They got advice from the IDB and from the World Bank. They met with the procurement, the equivalent of the procurement regulator in Jamaica. They looked at models all around and came up with Act 1 of 2015, what is now Act 1 of 2015. And on what you're doing, by simple majority, you want to dismantle that which was put in place by a special majority. Piece by piece, you're dismantling an independent institution by simple majority when it had been put in place brick by brick, line by line, provision by provision, by a special majority. Dr. Tiwari says the net effect of one of the early amendments was to reduce the power of the Procurement Board and to create a parallel structure of power by the creation of an appeals tribunal. They also came, this is their third amendment, also came to Parliament in 2017 to set up something that they call disposal of state lands. So they took disposal of state lands out of the procurement hands, but they also took disposal of things from a state enterprise and statutory authorities. So when we are there screaming procurement legislation, Petrogen could sell out everything. NIPDEC, sorry, not Petrogen, the Paria, Guaracara, NP stations, Port of Spain, all that gone, all gone, all gone. And now you're coming to further gut the law. You're further gutting it out, ripping the substance out of law in order to set up a parallel procurement system that unscrupulous individuals can use to their benefit. So it was the Express that said, gutting the Procurement Act. It was Mr. Riley who said, it is a travesty what is happening. Gutting the Procurement Act, and that's what we are doing. We are giving up the independent procurement person to keep in place the status quo, to allow corruption on the part of unscrupulous individuals to occur. That is what we are doing with this piece of legislation. So let's look at what's happening here with us. There's a judgment by Justice Jamadar in the Karen Court of Justice, in which he talks about the underpinnings of constitutionality. That constitutionality is not just about breaching sections 4 and 5, that there is a foundation that is found in the preamble of the Constitution. In that case, it was the Belize Constitution. We have it here in Trinidad and Tobago in our Constitution. That is the foundation. And when you breach those foundational principles, you are into the realm of unconstitutional behavior and action. My colleague will probably read some of the paragraphs from the judgment for you from Belize, and that really goes to the whole issue of constitutionality. So it's not just a text, he says. It's not just a text, it is the whole preamble which sets the stone to go forward, which is a jumping stone, the starting off point. He says that then, our Constitution demands from us that those principles of fairness and equity, of the rule of law, of transparency, accountability, and good governance, that those principles must be enshrined in our law. And that's what this procurement legislation was doing. So when we come to tamper with it, to dismantle it, to desecrate it, piece by piece by piece, by taking it out, then we are, in fact, madam, in a serious constitutional crisis. With those words, I thank you very much.
Prime Minister.